Welcome back, everybody. I hope you really enjoyed morning tea. To introduce our next session, I have the great pleasure of introducing and welcoming to the stage the Honourable Rod Roberts, MLC, Deputy President and Chair of Committees in the Legislative Council. Mr Roberts is an independent member who enjoys the rural lifestyle, cycling, running, travelling and assisting as a soigneur, did I pronounce that correctly? Excellent. To the New South Wales-based GPM Stultz cycling team that competes in the National Road Series. Mr Roberts has represented Australia in the 2015 World Duathlon Championships and is currently co-chair of the Parliamentary Friends of the Australian Constitution. As a former Detective Sergeant with the New South Wales Police Force and Senior Lecturer at the Police Academy on the Detectives Training course, Mr Roberts has a keen interest in law and justice in New South Wales and will now introduce our next session on how the 1823 Act impacted law and justice in colonial New South Wales. Please welcome Mr Roberts.
Well, good morning, everybody. Can I add my own personal welcome to you to Parliament House and also extend that welcome to those of you that are joining us via the live stream today. I'm enthused and delighted to see so many of you interested in our history, both as a colony and as a parliament. As you're aware, the theme for both yesterday and today is the spark, and that spark being the New South Wales Act. Of course, the Act led to the establishment of Australia's first legislature and was the foundation for the New South Wales Legislative Council as we know it today. The New South Wales Legislative Council is the first, oldest, and may I say in a completely biased manner, the finest legislative body in Australia. We heard yesterday from Brett Walker and Lynn Lovelock on the debate and parliamentary processes in England that led to the passing of the Act and what the intent of the Act was. The next session will delve into the world of law and justice in New South Wales after 1823 and the passing of the Act. The creation of the first Legislative Council under the New South Wales Act was a foundational moment in the reform of the colony's constitutional and legal architecture. It is suggested that it was designed both to temper the potential for tyrannical executive power and to guard against the dangers of representative democracy. And our next speaker contends that it was not so much a stepping stone towards liberal self-government as a careful constitutional reform for a socially suspect and politically boisterous colony. I hope we're still not described as that today. I'm especially interested in hearing from our next speaker not only what was in the New South Wales Act, but just as fascinating as what was not in the Act. It appears not much has changed in politics in 200 years. They say that it is not what a politician says, but more importantly what they don't say that you can draw inferences from. Well, it appears that the New South Wales Act may well be the same. Not what was in the Act, but what was not, may go some way to explaining the intent of the lawmakers back in England at the time. Now, to take us on the journey to explore how representation and power evolved within the new council, it is my pleasure to welcome back Associate Professor David Roberts, whom many of you may remember from our 2022 conference. David is an Associate Professor in History at the University of New England, where he researches Australia's colonial history and edits the Journal of Australian Colonial History. He is best known for his work on the history and legacy of Australia's convict past. His research is currently funded by a collaborative Australian Research Council grant for the project entitled Inquiring into Empire, Remaking the British World After 1815. We are all very fortunate to have someone like David here with us today, a true expert in the field and someone with such an incredible in-depth knowledge of colonial history. So please join with me in giving a very warm welcome to Associate Professor David Roberts.
Thanks, Rob, for that very, very kind introduction. I bring greetings from the New England region, which is the home of the Arnawan people on whose land I live and work. I also bring greetings and apologies from Professor Lisa Ford, who was scheduled to join me today, and had to withdraw at the last moment. That's a great shame because she leaves a great hole in the proceedings. Her knowledge, her legal knowledge of the sort of imperial background to the 1823 Act is exemplary, and I'll do my best to sort of fudge some comments in that regard. But anyway, we are of course commemorating the moment 200 years ago in 1823 when the Parliament passed the so-called New South Wales Act, otherwise known as the New South Wales Jurisdiction Bill, which gives a slightly better idea of its purpose. Section 24 of that Act authorised the establishment of the Legislative Council in New South Wales. However, it was another 5 months before the King, George IV, issued a warrant on 1st of December 1823 authorising the establishment of a temporary version of that council. It took another 6 weeks before that was posted out to the colony, and another 4 months before it arrived, and then a bit longer before the New South Wales Governor proclaimed the existence of the council, and then it was another few weeks before it held its first meetings in August 1824. So the wheels of government turned slowly in the 1820s. But that means that we can, over the next several months, look forward to celebrating various bicentennial moments arising from the passing of the New South Wales Act. So the council was, of course, part of a much broader package of reforms that were carefully tailored to suit what was at the time an extremely fractious and querulous penal colony. The 1823 Act simultaneously paved the way for a Supreme Court in New South Wales and a separate one in Van Diemen's Land. Less well known is the fact that the Act also platformed the jurisdiction of magistrates in the colony by authorising the creation of courts of general and quarter sessions. And that's a tier of justice below the Supreme Court. That's a lesser known but very instructive part of the Act, and it's something that hasn't been so well appreciated by historians, and I'll come back to that in a moment. The New South Wales Act did many things in many different spheres, but today we're primarily interested in its reforms to governance and justice. And we're asking about how these things should be interpreted and understood 200 years later. Now, I'm going to focus on the council. I think a lot of really good material was said yesterday about the Supreme Court, so I'll focus on the council. I'm going to look at its first phases up until the expiry of the New South Wales Act in 1828, at which time Parliament devised a new act which led to further corrections to the council and the judiciary. And I'm conscious that there's going to be others talking around this topic, so I'll try not to overlap. We'll hear more later about some of the personalities of the first councillors and a bit more about the political and social landscape in which the council operated. I'm going to talk in part about what the council actually did during its first 5 years. And it did a lot, so it will be a bit of a summary. But I wanted to begin by asserting a view, or reasserting a view, because Brett Walker covered this yesterday in a way sort of undercut a lot of what I was going to say, although he's far more nuanced. But my view is that the New South Wales Act was intrinsically minimalist. That is to say, it was not so much a great leap forward as a protective reassertion or formalisation of the status quo. It was meant to consolidate a range of circumstances and customs which had evolved in the colony over the last couple of generations. And just to explain briefly, that the creation of the Supreme Court and the appointment of a Chief Justice was significant, but in terms of the operation of the criminal law, nothing really changed with the New South Wales Act. The new court was almost precisely the same as the old criminal court, despite the fact that most of the colonists hated the old court. The new one was almost precisely the same. The British government stuck with a quasi-military model in 1823, essentially because it was avoiding the issue of trial by jury. What the British government did in 1823 with the court is essentially kick the can down the road, deciding that for now nothing much would change. Now, having written that, Brett yesterday, of course, was far more nuanced in his appreciation of some of the judicial reforms and the elements of judicial review. However, I'm an historian, not a lawyer, so I'll stick to my polemical version. But essentially, very, very little changed with the court. At the same time, the reforms to magisterial jurisdiction and the creation of sessions courts was really intended to formalise conventional practices in which magistrates played a primary role in the management and disciplining of convict workers. This had been going on for 40 years. But at some point around 1823, it was realised that there was no statutory basis for the authority of New South Wales magistrates. Commissioner Bigg didn't note it. he spoke a lot about magistrates, but he didn't really pick up on this idea that the magistrates actually didn't really have any constituted authority. In part because I think Biggs' judicial reform was actually a shocker. We can talk a bit more about that later, but it was an abysmal report for someone who came from a judicial background. So what the New South Wales does in establishing session courts is set up a system sort of similar to what exists in England, as if that's going to cure everything after that, and it didn't work, as I'll explain. And finally, you've got the Legislative Council, which really epitomises this thrust for formalising and normalising the status quo. Because what it does is assert a business as usual approach that involves very more than the appearance of change. It's attempting to imagine the creation of the council under the terms of the Act as a significant step forward for responsible government, and that it constitute a significant curbing of the immense power of the governor. If so, then it was a very small step indeed, and Brett yesterday called it a pre-embryonic step, and he's right. There was nothing at all representative about this body, and it would be some time before the powers of any New South Wales governor were substantially curtailed. Certainly the new council was a body that disappointed the demands and aspirations of colonial patriots and Democrats, and I think Frank may speak to that later. And we know from the limited evidence available that the Crown and Parliament did not intend to allow the colonists any such right or power at this stage. This was a reassertion of Crown power in the age of revolution. And the key clue here lies in the construction of this body as a council. So to quote from the New South Wales Act, it was not at present considered expedient to call a legislative assembly in this colony. So in other words, this is an advisory body, not a representative one. What the creation of the council reflects is an awareness that the local authority needed some capacity to make its own laws and ordinances. But that was not a noble or progressive concession, because the local authority had always made local laws as were considered necessary for the welfare and good of the people. The problem was that the power of the governor in that regard was not properly sanctioned by Parliament. And so by 1823, it's realised that all the proclamations and orders and regulations issued by the government over 40 years was all conceivably illegal. And this problem comes to the fore in the 1810s under Governor Macquarie. There's a raft of noisy and high-level allegations about his tyranny and arbitrary powers, accusations that he's behaving despotically. Now, what is interesting about those accusations is that they don't come from the convict population. They don't come from the sort of the subaltern levels of society. Rather, they come from the colonial elites who believe that their interests and status are being undermined by the governor's authoritarianism. In fact, the Commission of Inquiry conducted by John Thomas Bigg actually reveals no systemic evidence of tyranny. There's a couple of sort of headline examples where he's had some free people flogged and a few other moments, but what that inquiry reveals is a mountain of evidence of waste, bickering, cronyism and policy failure. Macquarie very much lost control of things towards the end. But there is no compelling evidence of tyranny in the sense as was experienced in other colonies. But the most potent concerns here are not to do with civil or political rights. At least that is not where the government is exposed. Rather, it's a problem to do with taxes and trade. It's about Macquarie's decisions regarding the allocation of internal resources, especially land and convicts. It's about monopolisation, tainted contracts and restrictions on trade. It's about fines and tolls imposed through the government's proclamations and regulations. So in sum, it's the concerns of capitalists, not convicts, that is of interest to the Crown and Parliament at this time. And so Parliament passes a series of acts beginning in 1819 to indemnify the governor from the consequences of having imposed illegal taxes. And the 1823 Act makes that indemnity perpetual. And Lynn Lovelock, I think, in some of the documents she uncovered yesterday, sort of proved that this was part of the decision-making process. So the creation of the New South Wales Legislative Council derives wholly and solely from an understanding that the governor needed urgently some legal protection for his decisions and policies. He needed the right to make his own laws with the express sanction of Parliament. But in the post-Napoleonic era, it's wise, for the sake of peace and good order and for the avoidance of scandal, for the governor to have some wise advisors around him, and most particularly that he should be required to seek legal advice. That's what the 1823 New South Wales Act does. That is the logic. And it's also a logic that, as we've learned, revealed itself at very late in the piece. It's not until the last sort of weeks of deliberations that they actually decide to put a legislative function into the Act. But the point is that this is not a representative authority. Only the governor can initiate legislation, although he can, and in fact he can override his advisors if they opposed his legislation. The council's business was conducted in secret. Members were required to sign an oath of secrecies to say nothing about what went on in their council. All local legislation had to be passed on to the British government immediately, and the Crown retained the power to veto any local law for whatever reason within a period of 2 years. And of course, what really evidences the limited capacity of this body is its restricted membership. I have a PowerPoint too. How does that work? I'm not quite sure how that works. The green button? It's not a very good PowerPoint presentation, but this sort of didn't really lend itself to that sort of thing. So you got, it's basically a council of between 5 and 7 members, most of whom are nominated by, or all of whom are nominated by the Crown, but 5 of them are high-ranking public servants, and we'll hear more about these people later, so I won't bite into that. But there are 2 members nominated from the colonial community, supposedly a nod to local interests. But these are in fact elite capitalists from the mercantile and agricultural sectors, so they're hardly men of the people. This council is hardly an independent liberal democratic entity. It rather serves to give legal authority to the astonishing gubernatorial powers that had ruled the colony for 40 years. It offers some modicum of self-government, but its primary intent is to preserve Crown power. There's a waning appetite for autocratic government in this period, but this is not a colony that can be trusted to govern itself. So that's my opening rant. Okay, but nonetheless, I guess the point I want to make is that despite this restricted architecture, or perhaps because of it, the council in its early days operates very smoothly and calmly and with little controversy. And I think in the early period, Carol might agree, this has a lot to do with Governor Brisbane's personality. I think I'm not quite as hard on Brisbane as many others, but I think he was very keen to have a council take control of some of his decisions and responsibilities in this regard. And by and large, although they all fought internally behind the scenes, on matters of legislation, the council and the governor got on reasonably well. They all sort of knew what had to be done. Up until the end of 1826, it passes 27 pieces of legislation. You can see that's a peak time in activity for the council. And I think that's essentially because there's a lot of outstanding business that they know needs to be taken care of. There's not a great deal of controversial matters taken care of here. And then for 3 years under Governor Darling, another 26 bills are passed. We know that the council did from the outset engage in meaningful discussions with the governor over its draft legislation. Time was taken to deliberate on the drafts that were presented by Brisbane's Attorney General. Defects were noticed and amendments were made. In the case of the January 1825 Harbouring Act, which is an extraordinary act passed, it's actually the third item that the council passes. It's designed to prevent rampant convict absconding. The council does appear to have given much thought to the probable impositions on the liberties of free citizens in terms of the power they were bestowing to arrest suspected runaways. They passed it nonetheless, but they did obviously have a good think and talk about it. The council dealt with many other overdue and urgent matters. There was legislation pertaining to liquor laws, which was a really important and vexed issue in a colony where people drank way too much and supported way too many sly grog shops. But the liquor laws are also very difficult. They revisit these over and over again, trying to get them right for many years. They passed a Parish Register Act in 1825, which requires ministers to keep official records of all births, deaths and marriages. And in doing so, they performed a most valuable service to modern-day historians and genealogists. In this great early flurry of legislation, there's acts concerning the recovery of fines, there's an act to establish a post office, an act for the better regulation of shipping in local ports, laws pertaining to tolls and fees, which are mostly about legalising some of the taxes that had been raised illegally for some time. As I said, these are all catch-up laws. But there's other laws that seem to be more proactive, and I'm particularly interested in an Act for the Relief of Persons Imprisoned for Debt, which answers a growing concern about the horrendous state of the Sydney jail at this time. Apparently it was just horrible. Harsh conditions being imposed on people, particularly who were put in jail for owing very small amounts of money. The council essentially passes a law which makes the creditor pay for the person's accommodation in the jail. It's to stop vexatious imprisonments. You know, someone owes you a few dollars, you send them to jail and make them suffer. It was actually seen at the time as being an act of humanity and common sense, or dare I say it, an act of good government. Most importantly, what we see at this time is ongoing work around the issue of indemnity. In fact, the very first thing the council seeks to do, it turns out to be its second bill, but it's the first one it debated in its very second meeting, is a bill to protect the government from all and any proceedings against it on account of previous decisions made by governors. The need to indemnify and confirm the validity of questionable practices becomes a repeated theme in the council throughout many years. In fact, I argue this is essentially what the council was designed to do. It's to sort of pass indemnity laws in conjunction with Parliament, which is doing the same thing. In mid-1825, the council passed a law expressly confirming that all its earlier laws were valid, essentially because it had been passing laws without the presence of the Lieutenant Governor, who was one of the nominated members of the council. He was out of the country, and then someone thought, oh, well, does that mean everything we've done is illegal? Let's pass an act. There's an act to stay proceedings against the colonial treasurers for collecting and receiving duty, so they're indemnifying the tax collectors for having possibly collected illegal taxes. But the most controversial act in this regard, is an act passed in 1825, and it's to give a stay of proceedings to colonial magistrates, and this one's particularly interesting. That was needed when it became apparent that magistrates had been acting not necessarily in accordance with the principles of British justice, meaning they were issuing illegal sentences to convicts. In short, what they were doing was engaging in all sorts of informal and spurious practices, the most sensational of which was ordering convicts to be flogged on suspicion, and that's on suspicion of committing crimes, and in order to extract confessions with regard to suspected crimes. So it's give this bloke 50 lashes and he tells us where he hid the stolen watch. Very, very suspect practices, and it all blows up into a big public scandal in the mid-1820s. And in this case, you see the Legislative Council beginning to perform one of its other key functions, which is to investigate problems and issues arising through formal committees of inquiry. So in this case, the council sets up a subcommittee, and it actually calls all the magistrates in before the committee and interviews them, and it gets all their bench records and it analyses them. They then go to sort of send that to a grand jury to get a sort of, which is magistrates investigating themselves, I think. But ultimately what it does is it prompts a bill to indemnify the magistrates against any lawsuits and criminal proceedings, such as might be conducted by ambitious and oppositionist lawyers hoping to make a name for themselves. And I think Frank and others will talk about Mr. Wentworth and some of the other characters. This is a time when we're starting to see increasing law talk, essentially people trying to make their careers out of filing lawsuits against the government. This is a critical development. It's an era of increasing litigation, much of it tied to political agendas. And the New South Wales, I think, very much sort of exaggerates this situation, because although it throws up a lot of questions about the reception of English laws and what laws are actually in force in the colony, and it tries to sort of sort some of these matters out, but it really throws up more questions than it answers, is what I'm trying to get to. I'm just trying to sort out my slides. Just before I got this, I wanted to say that the Magistrates' Indemnity Bill is the first bill which actually introduces a substantial difference of opinion on the council. I think the private members, the non-public servant members, were opposed to the Indemnity Bill because they thought the magistrates deserved to have their time in court in order to clear their names. They thought an Indemnity Bill was a blight on the honour and reputation of the magistrates, and they opposed it. But it nonetheless goes through. And it also opens a serious rift between the Governor and his Attorney General, Sax Bannister, who drafts the legislation that goes to council. Bannister thought it repugnant to the spirit of English law and refused to write the legislation. Brisbane told Bannister that opinion was beyond his pay grade and he had to do it, which he did. But it becomes law. The members of the council, though, do vote down a further inquiry into the magistrates. So you can see here a very clear role of the early council is to indemnify and cover up, I suppose, correct and cover up possible previous illegalities. It's a very, very interesting episode. It's about tucking away and tidying up the state of the law. So I just wanted to briefly talk about Darling's council as well, because things become rather different in the second half of the 1820s. I think things under Darling are somewhat more complex. They're certainly more tumultuous. The composition of the council has changed. That is, it is slightly expanded. There's a few adjustments to its procedures, and which I won't go into here. There is, however, a prevailing sense that the council did not work so well during the late 1820s. It passed fewer items, as we saw before, and it sometimes broke down amid acrimony and conflict. In particular, the Governor and the Chief Justice fell into dispute over Darling's attempt to prevent newspapers from publishing abusive and libellous content. And we heard a lot about this yesterday when we were in the Supreme Court, and it was spoken about in some of the sessions here too. I take a slightly different view. It's not all about Darling trying to muzzle the opposition media. He actually needed to sort of control and prevent some most abusive and libellous behaviour from newspaper editors at the time. I mean, some of the stuff they were doing was just frankly vile. Again, we'll spare the details, but this particular issue plunges the government into one of its most acute sort of constitutional crises in the early period. So these are headline political dilemmas, and those of you who know this period, Darling was involved in all sorts of scandals and problems. It gives an impression of disarray and dysfunction in the government, but that I think is belied by the fact that it also passes a number of very, very important pieces of legislation. The council behind the scenes continues to be quite productive. Behind all the noise and fury, there is a very solid and uncontroversial body of work being legislated. We see a new Bank of New South Wales created, which we spoke of before. A colonial census is activated in 1828. There's acts pertaining to auctioneers, the impounding of stock, and an act to regulate the theatre industry, which is particularly interesting. It's about crowd control rather than the morality of thespians. But it's, I read that one, that was interesting. And there's also master and servant legislation and attempts to address the illegal trade in government rations, etc. But I just wanted to raise one example before a conclusion. There's also simmering issues that the public doesn't know much about, and one of these is worth mentioning because it actually, behind the scenes, unnoticed to the public and unnoticed to historians, constitutes one of the great sort of crises of the period. And it again involves magisterial jurisdiction, and it reflects on some of the problems arising from the New South Wales Act. As I said, the New South Wales Act formalised magisterial jurisdiction through the establishment of sessions courts. In the process, it did two other things inadvertently. It did not accommodate the possibility that magistrates needed to operate outside of sessions. So magistrates who needed to sit alone in the remote districts or who needed to sit outside the normal schedule of sessions courts weren't covered by the law. And this is a really serious mistake in a colony like New South Wales that has remote settlements and expanding frontiers. Even more seriously, the Act potentially concedes that prior to 1823, magistrates had no formal jurisdiction over convicts at all, that they did not have previous authority to issue certain sentences, such as retransporting convicts to penal stations. This is a very serious predicament, and it's noticed in the council. And it's, as I said, one of the key respects in which the 1823 Act doesn't really understand the repercussions of its provisions. This crisis, however, is dealt with quite effectively and very discreetly by the council. It passes this, it's the so-called Port Macquarie Act, which was the main penal settlement of the time. It's an act that's very skillfully constructed and essentially legalised colonial penal settlements as transportation zones, authorising them to receive convicts sentenced to transportation under British law. And in doing so, it brings New South Wales law into line with recent English acts pertaining to transportation and exile. Section 6 also provides further indemnity for magistrates, which clearly was a main part of the Act. As I said, it's barely noticed by the public, by the historians. They actually quietly repatriate about 400 convicts back from Port Macquarie and release them back into the sort of normal spheres of work. It doesn't end the really serious situation that arises from magisterial jurisdiction. That doesn't get solved for many years. But this law comes up over and over again in subsequent legislation and court cases as basically some of the definitive answers to these perplexing questions. And so I just wanted to sort of mention that as a means of showing how the New South Wales Act threw up all these really serious questions, and that the council, for all its faults, is actually quite effective in meeting these crises. So in conclusion, as we know, time wears on. There's a growing public pressure for the reform of the council. A lot of it gets couched in the assertive language of the freedom of Englishmen. If anything, this truncated, limited legislative model created by the Act does much to inspire the indignation and audacity of the colonial opposition. It gives them something to rail against, something to fuel their talk of autocracy versus democracy. And that's what the real spark of the 1823 Act. It ignites a more vocal and radical movement for democracy. And of course, what it does, all that noise and bluster, helps persuade Parliament not to give the Democrats what they want. Because when the Act expires and the new one comes out in 1828, they dampen the spark. They retain the same sort of nominated council. There's an increase in the membership, there's more local landholders and merchants, the veto power of the Chief Justice gets removed and the oath of secrecy gets removed. And it becomes slightly harder for the Governor to enact a law without the approval of the Council. But these, again, can be seen as a significant step down the road towards a modern legislative system, but they were very, very small steps indeed. Okay, thank you.
Well, thank you, David, for such an insightful overview of the period after 1823 and the enactment of the New South Wales Act. Look, we're going to take questions and answers now. If you have a question, please put your hand up. We have a number of roving microphones, and away we go.
Hello. I'd like to ask a question about the royal prerogative of mercy.
Yeah.
Apart from the toll puddle martyrs, was that ever used in the early colonial time?
In New South Wales, extensively. Yeah,
extensively?
Yeah. That power was vested in the Governor, who's the royal authority. And then from 1825, 1824, it gets vested in the executive.
Right.
So I didn't go into this in this talk, but in 1825, they sort of split the Legislative Council into an executive body of 4 members who were then joined by the public members to be a Legislative Council. So at the beginning of this sort of bicameral sort of approach, but it's kind of not.
So it was used extensively?
Yeah, they get to, the Chief Justice will come to the council and say, look, I convicted these blokes, but they're young, or there was no violence involved. But they use the royal prerogative and commute death sentences extensively, because if they didn't, it would be a bloodbath. The law reforms to reduce the number of capital crimes doesn't really sort of happen until the mid-1820s and on. So, as in England, they use it extensively.
Thank you. Further questions? Yes, please.
Hi. I'm interested in your more tolerant view of Darling. Do you think he suffered from all his attempts to reform the administration and the finances and whatever? He was actually the patron of William Lithgow. He brought him from Mauritius with him.
Yeah, that's right.
And he used him extensively for a lot of his reforms, but he really did try to get them through, and I wondered whether he suffered from people unwilling to change.
I think he most definitely did. I think he was probably the wrong man for the times, Carol. You think like he was... This is... the late 1820s is when the reforms from the Royal Commission really start to hit home, and there's big pressure to institute reforms to the bureaucracy and the way the colonies run. Darling was probably not the right man for it, because he is a very severe military-style person. And yet, on the other hand, he's facing a largely incompetent public service. I'll keep using an example of his Attorney General's deaf. I don't know, operating courts. Don't wish to be rude, but I mean, you look at the incompetence of all his public officers and the sort of petty things they threw in his way. And when I read the Darling papers, I just get this sense of, oh my God, it must be so frustrating for you, mate. And as I think Frank and others will talk about later, this is the time when the opposition in the colony really, really starts to ramp up, and they bait Darling very, very successfully. And they have direct communications to the opposition in Parliament. So Darling's getting nailed in Parliament. So he becomes a tool by which the sort of opposition in New South Wales and London basically hammer the government, and he got very much caught up in that. But the best account of this is A.G.L. Shaw's book. What's that called? Heroes and Villains, where he talks about Governor Burke, who's the great hero of Liberal Australia, and Governor Darling, who's the autocrat, and actually reverses that and shows a different, the exact opposite take. But yeah, I don't mind Darling. All politicians should read about him, I think, as a way of how not to do things, unfortunately.
Both you and Brett talked about how this act is essentially conservative in maintaining the power of the governor.
Yeah.
And Brett especially went into detail about some of those powers. Were there ever occasions during disagreement between the Legislative Council and the governor where the governor did activate, for example, I think the less extreme one where if he had one member of the council on board, he could pass something if he thought it was necessary?
We don't really know a great deal of what the Legislative Council did at all. Its minutes are very perfunctory and brief. And as I said, they weren't really allowed to talk about it. The main thing that happens is that the Chief Justice and the Governor disagree over legislation. In the case of New South Wales with Forbes and Darling, I think that's largely a political plays. I know that in Van Diemen's Land, where Governor Arthur had much less patience for his Chief Justice and his council, he did just tell them I'm passing this anyway. I think that was particularly over acts to do with increasing magisterial powers over convicts and police powers and things like that. He just said, I've got to do it. The place is a mess. This is my power to do it. Yeah. It's not. I don't know when we start to get really transparent proceedings from the Legislative Council, but it's not until much later. So we don't really know, and the press didn't know much about it either. I think, is that right? Fair to say, Frank? Yeah, there's not much there's surprisingly little public debate about what's going on in the council, which is also evidence that it just acted quietly and effectively, I think, and did what it had to do in these years. Made a few mistakes, but it operated, probably because it was a largely unrepresentative and undemocratic body. At the time, it just got down to its business, I think.
Thank you. I'm mindful that we have some participants online, so I'm just looking for Lauren. We don't have any online questions, so please, anybody from the audience, please go ahead.
The forward estimates and moving forward to 1839, it seems to reason from reading the newspaper accounts of what was happening in the Legislative Council, that the governor had to go cap in hand to the Legislative Council to get approval for forward estimates. How did that come about if there wasn't a change in the Act that instructed him to do that?
That's a very good question, and I can't answer it easily. There were renewals of the Act more or less every 5 years, I think. I'll keep looking at Carol, who's the colonial history expert that I always defer to. But I think by the 1830s, late 1830s, it's a very, very different situation, and you're starting to, by then, see the early anticipation of responsible government. Certainly in the 1820s, I don't think there's any discussion of forward estimates. They had the privilege of just spending what they needed to spend. And the governor, the point is the governor still had the council had very firm control over all of this. Yeah, so I think 10 years makes a big difference in terms of the build up towards a proper Legislative Council.
Further questions?
Thank you. Just on that point, have you got any comment on the question of demographic change, that a lot of these small steps were made possible because, as you say, by the 1830s things had changed, but certainly by the 1840s, it's a different kind of colony, and there are different different pressures from society by then.
Oh, absolutely. So with the end of the convict system and the transportation of convicts to Australia, it becomes no longer tolerable to have the sort of legislative council that we saw set up in 1823. But even by the 1820s, the number of free immigrants, ex-convicts and colonial-born people is becoming so substantial that it's even then it's highly questionable as to whether you can continue without a representative council. The question of the council follows more slowly than the question of the courts. I think the really big issue here is the courts and trial by jury, the right of free Englishmen to be subjected to normal processes of law. And this is where the rubber really hits the road for the conservatism of the British government and the 1823 Act. That's where I think, Frank, this probably we'll talk about later, is that this is what really ramps up the opposition, is this idea that Englishmen in Australia don't get access to proper court systems at this time. They care much less about the Legislative Council, I think. But demographic change is certainly really, really critical throughout the whole period. Everything changes after 1815. Thanks.
Thank you.
Hi, David.
Is that Gary?
Yes. I wonder how, I mean, this is a hypothetical, but I wonder what proportion of people in the colony would have actually qualified to vote if they'd remained in England. Because the franchise in England was extraordinarily restricted.
Very restricted, yeah.
Up until 1832, and then there was a small expansion for property holders, but it was really only 1865 and beyond that, more of the populace got the vote. And so I wonder whether, in a sense, the rights of freeborn Englishmen to a jury is something that everybody experienced, but very few people in England or coming from England would have actually had the right to vote.
Yeah, I think anything that we would recognise as representative democracy was a pretty foreign concept in the 1820s, both in England and here.
Yeah.
All those developments are down the track. But what is interesting in New South Wales is not so much discussions about who votes as to whether you can sit on a jury or not. That's the more poignant question. And there's a lot of debates and there's a lot of evidence collected that we could come up with this many jurors or we can come up with that many jurors there. And opponents are saying, well, they're not going to turn up to a jury anyway because they're too busy looking after their farms. So the debates, again, coming back to the question here, is it tends to be around the courts and the rights in sort of civil and criminal cases, rather than a question of whether someone is represented properly in Parliament in the way that we understand it today. Yeah. Thanks, Gary. It's a good question.
Thank you. Yes.
I think it was in 1829 or perhaps 1830 that the Council reenacted verbatim the terms of the Roman Catholic Relief Act that had been passed by the Parliament in Westminster. It includes a whole lot of provisions that had nothing to do with the colony, such as Jesuits should not sit in the House of Lords, and things like that.
Yeah.
Any idea why that was such a rough job?
I'm not really sure precisely on that, and I'd rather leave that to people that study and are experts in that, because it's very complicated. But there is one of the things that the Legislative Council, the introduction to the Act does, is it complicates the question of what English laws are received in the colony. So there's an understanding that all Crown colonies receive English law until the point that they get their own legislature. And that happens, of course, in 1823. After that, and there was something else I didn't really get time to go into here, and Lisa would be better at it. There's a whole heap of really pressing legal questions that arise as to what English laws are in force in the colony. I don't know about religious laws and education laws, but in the criminal law it's very poignant, because at this time they're reforming English law. They're actually repealing a lot of acts. And so in New South Wales, they're convicting people of criminal offences that are no longer criminal offences in England, sometimes resulting in groups of 30 people being convicted convicted to death and then being released, because there's debates about what laws are in force. And you see that some of the acts that are brought in are reception laws in New South Wales, where they say all laws in force all these laws, and they name them, are now enforced in New South Wales. And so they've got to do that to actually consolidate and clarify the state of law in Australia. So I can't answer that question precisely, but it would be caught up in much the same thing. And it's possibly an attempt to extract what is applicable to the colony. So they don't necessarily just take wholesale English law and introduce it in New South Wales. They'll take bits and pieces as suits them. And I think that increasingly happens in the 1830s, is my guess.
Okay, next question. No questions?
Oh.
You've exhausted them,
Yeah, you warm me out.
Exhausted them.
It's lunchtime.
Well, if that's the case then, can I thank you all for not only your attendance this morning, but your actual engagement in asking questions of David. And if I could thank you, David, once again for a very in-depth and concise overview of what. And if I can say just this in closing, thank goodness we've come a long way in representative democracy to today. So thank you very much.